topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Tampa. Welcome to another Ask the Expert show where for the last, it's almost 17 years now, we have brought you top experts in the field of legal, health, financial, and home improvement. Hey, this is for the next 50 minutes. This is a very special show. K. Bender Rimbaum, they're a community association law firm based out of Pompano, Florida, with offices in Tampa, Orlando, and Palm Beach. Were one of our first experts to come on board with us. We were still doing radio when they came on with us, and now we've grown so big. This is a great show. Our Tampa show, we have been watching the numbers, and they are getting up there. It's amazing. I understand how much people love this show. Let me welcome our expert, attorney, Kirsten Hens. Good afternoon.
Good afternoon, Steve. Hello, everyone.
I got to tell you, we're so glad to have you. People love the way you respond to their questions. And by the way, we got enough questions in for your show to last us for the next year. But we've only got 50 minutes, and we've kind of called them down, and we'll probably ask a lot of the ones we didn't get to next month. You're on the last Tuesday at 5 o'clock Eastern time every month, and I cannot, first, we're getting so many new viewers, Kirsten. Tell people about K. Bender Rimbaum.
Yes. Again, hello, everyone. I'm Kirsten Hensa, and I am a partner and managing attorney of the West Coast office for K. Bender Rimbaum, which is located in Tampa. The firm is a community association firm, which means we only represent condominium, HOAs, and cooperative associations in the state of Florida. As Steve mentioned, we have multiple other locations, and we have, 26 attorneys now throughout the state of Florida. I personally have been practicing law going on 18 years, and I've been with the firm since 2010.
Though she looks like a kid, so we don't believe that.
I'll tell you, I am feeling my age.
Oh, no. I got to tell you, you look great. Love the hair. I got to tell you something. It used to be people were moving down here. They would move to Palm Beach, Boca, probably Delray. I can't believe all the people from up north that are moving to Tampa.
Yeah, I mean, I myself moved here about 3 years ago, originally from South Florida, which is where I started at the Pompano office. But I mean, the area is great, and I think it's the slower pace. At least I feel like it's slower, in South Florida. So,
but I bet like every 10 letters we get, 7 of them are people who are moving to the Tampa area. And it's just recently happened in the last 4 or 5 months. So I hope they're ready for all these new people moving in.
Yeah, I got a sense from the line of questioning, the recent line of questioning, that a lot of these individuals are not very familiar with Florida condo HOA laws. So yeah, I'm excited to start answering some of these questions. We have a lot today.
We do. Okay, let's get started. We're going to start off with Michael in Tampa. He said, I know HOAs have mediation, but do condos also offer mediation?
Yes. So it used to be that the condominium statute required the association and unit owners to go through pre-suit arbitration before a lawsuit could be filed in court, which is a much different process than mediation. The statute was changed several years ago to now allow mediation in lieu of arbitration. So now the parties can either arbitrate or mediate before formal legal action can be pursued on the particular dispute.
Jerry in Tampa wants to know, is it legal for a board member to not own a property in the HOA? And a follow-up question is, and can spouses serve on the same HOA board, or is that a conflict of interest?
Well, if we're talking about an HOA that is subject to Chapter 720 of the Florida statute, there's no prohibition for spouses to serve on the board at the same time. That is not the case for condominium associations governed under Chapter 718 of the Florida statute. So with condominium associations, spouses cannot serve on the board at the same time unless they own more than one unit or there are not enough candidates on the board. In terms of the ownership, it sounds like the owner or this board member is asking about, ownership of property as a qualification to serve on the board. In other words, some documents might require that a director be a record owner, right? So a member of the association. And that's not necessarily something that's addressed in Florida statute. So it would be very specific to the governing document of this particular community. So I would encourage you to take a look at the Articles of Incorporation and bylaws to see what the qualification for directors are and whether you are required to be a record owner in order to serve on the board.
Hey, Gerson, what I've learned from you, when in doubt, look at the docs, right?
Yeah, and that is even more true with HOAs. They're not as statutorily heavy as condominium associations.
We get all these letters, and I always forget to remind everybody, it is so important. There's different rules for HOAs and condos. So if you will, let us know if you're an HOA or condo, because it makes a huge difference. Let's go to Alson in St. Pete.
It does. And if I can just say one other thing, Steve, I know board members and owners also sometimes use the word HOA to just refer to an association. So sometimes when owners mention, oh, I'm in an HOA, I'm still not quite sure if that means a condo HOA or homeowners association under Chapter 720. So it'd be great if they actually specify what HOA they really mean.
Oh, that is so true. I never thought of it that way. I've been to one of the, I forgot if it's called Ask a Lawyer. I know that Robert and Michael do it down here in South Florida.
Yeah.
And I got to say this because I've been to several of them. And there was a gentleman, a resident, he said, I come here to ask one question, and then I'm out of here. He was telling the guy next to him. That guy ended up asking more questions. And it's kind of like this show. People have a question and all of a sudden they think of something else. So we see a lot of same people writing new questions.
I have noticed that.
Yes. Okay, so this is Alson, I guess that's how you pronounce it, in St. Petersburg. Can one board member alone issue violations or fines? Should a fining committee be independent from the board? And are fines enforceable if due process was not followed?
So, multi-layered question. So certainly, a fine that has not been properly adopted in accordance with the statute is subject to legal challenge, which is why it's very important that boards and committees follow the statutory process. So, generally speaking, it shouldn't be, one board member issuing violations and certainly not imposing, fines, by themselves. So there should be a board decision. And the statute really defines or outlines the process by which a fine can be imposed. And it really it's a two-step process. So the first part is when the board adopts the fine, and that needs to happen at a board meeting, duly noticed, typically 48 hours in advance of the meeting. But then once the board adopts the fine, the statute is very clear that the fine cannot be imposed until the owner has had an opportunity to meet before a fining committee and dispute the fine. And then only if the fining committee affirms the fine, then can the fine be imposed. So that committee meeting has to happen at least 14 days from the date that notice of the hearing is provided to the owner. And the committee absolutely needs to be independent from the board. The statute makes it very clear that the committee members cannot be directors, cannot be officers or employees of the association, nor spouse, sibling, parent, child, anyone residing with these individuals. So, I recognize that from, some associations, getting an independent fining committee might be difficult, especially for the smaller associations. And so fining, might not necessarily be a viable option for those communities. But I always remind, board members, it's just one among other remedies available to associations to address violations.
Here's a question. Can I legally record a financial COA meeting when providing advance notice to the board and management? I was given a legal letter telling me this was illegal as it's not a board meeting.
What kind of meeting did the listener say was?
COA?
Okay, condominium association, I'm assuming. But
Yeah, it must be.
an associate, okay. It didn't say it was a board meeting?
It says, can I legally record a financial COA meeting when providing advance notice to the board and management? I was given a legal letter telling me this was illegal. It is not a board meeting.
I don't know what I'm presuming it's a condominium association meeting at which, financials were discussed. It's unclear if it's a board meeting or a membership meeting or a committee meeting, but the bottom line is that unit owners do have the right to not only attend, membership and board meetings, but also to record them. Now, the board does have the ability to adopt reasonable rules, right? Which may include some kind of advance notification requirement, letting the board know that the owner will be recording, perhaps rules regarding where you can put the video, the camera. But at the end of the day, owners do have that right.
Kirsten, we're right around the corner from hurricane season. And people are starting to ask that are new. It sounds like they're new to their association. does Cape and the Rimbom, do they do a some kind of seminar on I guess on these kind of storms that come up that we get so many of with hurricane season right around the corner? Do you all do any conferences or seminars like that?
I mean, we do from time to time, yeah, participate in panels with other experts where we discuss about hurricane preparedness and
Yeah.
other similar issues. So I we might have had one in the last month, if I recall correctly. But I would just encourage the listeners, just go on our website. We do post a calendar of all of our upcoming webinars and then in-person panels and events. And all of those events and webinars are free of charge. So check out our calendar and attend any of them.
You've got so much great information on your website. People should go there to check it out. We're going to go to Laurie in Clearwater. Can homeowners sue their HOA board for spending money on property that the HOA does not own?
I mean, we live in a litigious country. I wouldn't say world, but definitely country. So anybody can sue anybody, right? It's not outside the realm of possibility. But using association funds for property they don't own or for non-bona fide association expenses, can be problematic. So, I would just encourage the board members to seek legal guidance before using association funds for purposes that might not necessarily be as clear.
Yes. Craig in Clearwater, a lot of Clearwater. Can an HOA refuse or delay access to documents like the bylaws, government docs, or HOA financial records? And can homeowners request an independent audit?
So, the association should not be delaying and certainly, should not be withholding official records that are accessible by owners. And the statute, both 718 and 720 outline, a laundry list of records that are considered association records, which are accessible to unit owners. And there is a time frame within which, the association has to provide access to these records, which is, within 10 business days of receiving a written request. Now, for HOAs, the request does have to be sent by certified mail, but they shouldn't be withholding unless, of course, maybe some of the records are privileged and not accessible to owners, such as, for example, any communication between legal counsel and the association, right? There are other records like, records that are obtained in connection with the approval or disapproval of a sale or a lease, right? Those are not accessible, but governing documents certainly are accessible to unit owners. In terms of an independent audit, I suppose if an owner requests financial records, they can use those financial records to then, have an independent audit being performed at the owner's expense. Audits can be costly. An alternative is if 20%, at least for HOAs, if 20% of the membership petition the board to undertake a financial report that is higher than the level that they're required to do under the law or under the governing documents, then the board can actually is required to conduct a membership meeting, and then upon a vote of the majority of the owners, you can force the board to undertake whether it's an audit or some kind of a higher level of financial reporting than they're required to do. So those are some of the options.
Okay. I guess I want to remind everybody you have offices you're in Tampa, you have an office in Orlando, Palm Beach, and Pompano. Pompano being the main office. Let's go to Matt in St. Pete. Is the property manager's job to verify the 80% age rule, or is it the board's responsibility?
So, what this call is referring to is the 80-20 rule, which applies to communities that are qualified as housing for older persons, right? So those 55 and older communities. If you are one of these older communities, then the requirement for you to keep that exemption, right, is that at least 80% of the parcels or units in the community be occupied by at least someone who's 55 and older. So one of the requirements to keep that exemption is that you need to, confirm the occupancy, right? Ultimately, that job, that responsibility falls on the board, right? On the association. Certainly the property manager is there to assist, but that's ultimately, the responsibility of the board.
Okay. We're going to go to a break. Tell people how they can reach your office.
Sure. Our main office number is 954-928-0680. That is the number for the South Florida office in Pompano, but with a click of a button, the reception can refer any call to any office throughout the state. So,
okay, we're going to go to a quick break. We're here with attorney Kirsten Hens. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
Back. This is the last Tuesday of the month. That means K. Bender Rembaum, the Community Association law firm with offices throughout Florida. We're here with attorney Kirsten Hens. Let's go to Abe in Tampa. He wants to know, and we're getting a lot of these now, can you record HOA meetings on camera or audio?
Yes, that was very similar to the question from this other caller or viewer. Yes, under both condominium and HOA statutes, owners do have the right not only to attend meetings, but also to record meetings. Keep in mind, though, the board, again, does also have the right to adopt reasonable rules concerning the recordings.
Kirsten, can you have someone who is not in the community sit in for you if you can't make a meeting?
You mean like have another owner attend on your behalf, or someone that's not
A friend.
a friend? Well, the answer is no. Meetings really are reserved for the membership of the association, unless, of course, the board allows or authorizes attendance by someone else. If an owner can't attend and they've given a power of attorney to someone else, certainly that individual can attend on behalf of the owner.
Mike in Clearwater wants to know, is there a legislature to require audits for condo associations?
Well, there is legislation. I mean, it's been in the statute for as long as I can remember. But Chapter 718 does require audits for condominium associations that have annual revenues in excess of $500,000. That is the current threshold right now. It's been the same threshold for many years. I know that there is, many residents have expressed a desire for that threshold to be changed. But whether or not that's ever going to make it in the bill, unclear. I don't expect anything of this type of change to come out of this legislative session.
Vance and Brandon, I am on the board of our HOA. This is the month of April, and I cannot get January 2026 bank statement. Do I have the right to go to the bank and get it?
I'm unclear why he wouldn't have access to the bank statements. I don't know if that's just the association not having a copy of this record. The only way that he could try to get a copy from the bank is if he is an authorized signatory on these association bank accounts. And if not, then typically he'll have to go through the signatories or the property manager.
Phil in Clearwater, can the HOA refuse to hold an election at the annual meeting because of the quorum rules for meetings?
Can they refuse to have an election? Well, with HOAs, in order to be able to conduct an election or the annual meeting, the number one requirement is that you have to have a quorum of the members present. And quorum means basically the minimum number of owners that have to be either present in person or by proxy in order for the membership meeting to continue. So with HOAs, if the association doesn't meet the quorum requirement, then you really can't conduct any business, any of the business on the agenda. So you wouldn't be able to hold a meeting or go through any other agenda items. So it's not that they can refuse, it's just that it's a legal impossibility to have a meeting if there's no quorum for HOAs.
Okay. We're going to go to JD. By the way, because I don't know why we get the letters. People who are complaining about their board, I think Kirsten will agree with me. Run for your board. If you're trying to get changes made, run for the board. I mean, a lot of times people are writing us saying they don't have enough people for their board. Run for your board. Get those changes made, correct?
Yeah, I mean, I don't disagree.
Okay. We're going to go to JD in Tampa. It's kind of a long question. He said, we have a board member who has been on the board for 13 years. He will be placed on the board again on May 15th at our election. Can he serve past 8 limit year by the new statute? Can he serve out term? We have other owners who want to serve on the board when his 8 consecutive year expires. Will he be able to serve out his full term, or is he off as of July 1st, 2026? That's a mouthful.
It is a mouthful. Unfortunately, the one key part of this question that or the information I need to answer the question was not provided in this little fact pattern. So this law or the statute that the caller is referring to, I mean, it's definitely not new. It took effect July 1st of 2018. And so and the statute clarified that it's the 8-year term limit starts as of July 1st of 2018. So while this director may have been serving on the board for 13 years, I don't know whether he's been on the board 13 years. Well, it wouldn't even make sense. Obviously.
Can you serve
okay,
that
no.
long?
Yes, he's no. Then he has served. Yeah, doing my math. Of course, I'm like a lawyer, not a mathematician. So, right. So the 5 years prior to, oh geez, we're in 2018, 19, 20, 21, 22. Right. So the time he served prior to July of 2018 would not count. So he's very likely able to run and serve out the rest of the term, but for the next annual election, he would not be entitled to run.
Okay. Let's hope this is an easier question. Can an owner quote and cite Florida statutes or governing document provisions?
Say that again?
Can an owner, it doesn't even make sense to me, can an owner quote and cite Florida statutes or governing document provisions? I don't understand that question.
I mean, sure.
Okay. This is on a board of director meeting agenda. Is this member exclusion legal? 8, executive session, HOA delinquency and beautification report. I don't understand that one either. Do you?
I don't think I understand what you said.
Try to make these questions.
There has to be a question mark at the end, not just a statement. I can't do anything with statements.
Okay. Someone just asked what questions can be asked for screening. That's okay. Let's get back to our letters. Okay. Molly and Brandon, we are an HOA. We only have 2 board members and we can't get a 3rd board member. How do we get anything done to our property? We have tried so hard to get a 3rd board member. We can't trim the trees or pressure wash. What is your suggestion?
Well, if this is a 3-member board and there are at least 2 directors serving on the board, you already have a quorum of the board, which is the minimum number of directors that you need in order to be able to conduct association business. So while having a 3-member board would be ideal, you can still function with a 2-member board. So you can conduct business. You can have your meetings. You can establish quorum with 2 out of 3, as well as, conduct any kind of business, sign contracts, approve vendors, etc. So I don't see an issue unless the fact pattern is, maybe the board members are confused of what the actual size of the board is. But if the documents say that you have to have a board of 3 or no less than 3, and that's the number of directors you've had on the board, and you have 2 currently serving, then sounds like you have a quorum of the board.
Does Tampa have a lot of 55 and older units?
Communities?
Yeah. Are there many?
I mean, yeah.
We have a lot here in
and we represent a good number of communities that are housing for older persons.
Okay. Rebecca in Tampa, she's a condo, their docs say all people who live in condos must be 55 or older. Can a daughter under 55 live in the unit?
I mean, I would have to, obviously see the actual provision, but I would venture to guess that what the provision actually says is that, which is what fair housing laws provide, is that if you are a community that's qualified as a housing for older persons, in order to maintain your status as such, each unit has to be occupied by at least one individual who's 55 years or older. No one under the age of 18 can permanently reside on the property. So the daughter of someone who is at least 55 years of age or older can live with the older occupant, provided the daughter is over the age of 18 and that individual also resides in the unit or in the property.
Okay. Another Brandon getting a lot of from Braden. Craig, is there a legal way to verify that an animal is actually a service animal and the letter submitted is legitimate? We suspect there are owners who have submitted false documentations. We used to get a lot of these. We don't get as many anymore.
So, how you can verify if the letters are legitimate? I mean,
they're kind of doubting if these letters saying they're a service animal are legitimate. Is there a way to prove it?
Well,
I think they're animal lovers, Kirsten.
Well, they're entitled to have a no pet, community. That's part of living in a condo or an HOA, right?
Right.
So, unfortunately, so associations do have the ability to, inquire and confirm the disability of an individual or the disability related need of an individual under limited circumstances. Right. So if an individual, for example, is, blind, the disability is readily apparent, right? And the need for the animal is readily apparent, and they provide you with a medical note, you wouldn't be able to go beyond that. The tricky part is obviously when the disability is not as apparent or the need for that assistance animal, whether it's an emotional support animal or a service animal. In those cases, there are questions that you can ask of the individual to have their provider, whether it's a medical provider or a social worker or any third party that can verify. And believe it or not, I mean it can be even a rabbi. I've had these situations. So you're not limited to just having a doctor confirm the disability or the need for the animal, right? But if you're in one of those situations where you can ask additional questions, I would strongly recommend discussing with legal counsel the option of approaching the owner and then asking these additional information. Unfortunately, if they've provided you with everything you need, asking additional questions in those circumstances could potentially expose the association to liability. So when in doubt, just, seek legal guidance on these types of issues.
This is from Gina. Is it legal for an owner who owns the majority of lots in a condo association to control the board of directors without a vote of the rest of the members?
That is a good question, and I think I need a little bit more facts. So let's
see if they write.
Let's move on. I won't be able to answer that one.
Okay. You can take your time on this question. It's a short question, but you might need a little extra time. This is from Ken in Plant City. He wants to know, is there a difference between condo and HOA laws for 55 plus?
So if the question, there's no differences in how the law applies to condos versus HOAs. For condos and HOAs, which are generally referred to as community associations, just note that it's the Fair Housing Act that applies, the federal and state fair housing laws, not the Americans with Disabilities Act. There's always this confusion that I see among board members and owners. The Americans with Disabilities Act applies to places of public accommodation, so libraries, airports, right, museums, restaurants, that type of thing. They do not necessarily apply to community associations unless, of course, you're in one of those community associations where you do provide access to the public. And I don't mean, having guests come over, having, outside family members. I'm talking about, perhaps a condominium association that has a restaurant as one of their units, right? These sort of multi-use type of communities. So in those instances, Americans with Disabilities Act may apply. Otherwise, Fair Housing Act applies, and it applies across the board for condos and HOAs.
Sounds like someone's trying to make a decision. They want to move to an HOA or a condo association. Lee in Tampa, if the board president signed a construction contract without a board meeting, should there be written proof of the board member votes?
I would think so. There should definitely be board minutes of a meeting at which the board approved the contract. Certainly for condominium associations, there is a new requirement. Well, not so new. It went into effect a couple of years ago, where if the board is going to be approving a contract, whether it's construction or any type of contract, a copy of the contract has to be provided with the notice of the meeting at which the board will be adopting the contract. So typically, notices of board meetings at which a contract is adopted has to be posted only 48 hours in advance. So that would mean that a copy of the proposed contract would need to be at least posted with the notice wherever notices are typically posted. No similar requirements for HOAs yet.
Okay. Kathy in Tampa, if a board rolls over, do they have to take the class as re-elected board members?
So that is, it's a very generic question because there are different certification requirements, and they're not necessarily the same for condos and HOAs. So for HOAs, the first board certification class, if you will, that needs to be taken by a board member within 90 days of being elected. That one, if you are reelected, that certification is good for until 4 years. So every 4 years, as long as if you serve uninterrupted, every 4 years you have to take that board certification class. Now, that's different from the continuing education requirements that board members of an HOA have to do annually after taking that board certification class, right? And then the hours of how many hours you have to take depends on the size of your community. So if you're a community of less than 2,500 parcels, then you have to take 4 hours of continuing education. And if your community has at least 2,500 parcels or more, then you have to take 8 hours of continuing education. For condominiums, you have this board member certification class, right? That 4 hour, the one that everyone complains about. So that's a 4 hour certification class, and the certificate for that class is good for 7 years as long as you serve on the board uninterrupted. But again, once you've taken that board certification class, you still have continuing education requirements annually, right? And you have to take at least 1 hour of continuing education if you're in a condominium.
Rich in Tampa, how can the membership remove a director from their position?
So the only way that you can remove a director is through the recall process. And that is a process that is both in 720 and 718, and it's a very detailed process for me to go through it on air. Just suffice it to say, it can be either done at a membership meeting or it can be done by written ballots. Okay, so I would just Google the statute, do a search word for recall, and it should be there.
Okay, Freddie in Lutz, what if the board wants to discuss taking legal action against a homeowner? Still need to be an open meeting? Only if meeting with legal counsel, is that open?
Well, if you're going to discuss, proposed litigation, taking legal action against an owner, or if it's concerning, pending action, then yeah, you can certainly meet with legal counsel in a closed meeting. You would still have to notice the meeting to the membership, with date, time, location. Just, you'll notate on the notice that it is a closed meeting with legal counsel.
And we're going to end up with, this is kind of similar to the question about the 55 plus. I have a person that wants to buy into a 55 plus, but only live there part-time. And a 20-year-old son will be there full-time. Would this be allowed?
Well, I mean, that could be problematic, right? Because typically the son would need to live in the unit with the unit occupied by someone that's 55 years of age or older. So the if the owner's not going to be living there permanently, that could be problematic. So I would seek further legal guidance with association counsel on how to approach that.
Kirsten, I got to tell you, we throw all these questions at you, and I think we should start a show, Stump Kirsten. You do so incredible. You really got to be on your toes. That's why, I'm sure you've been with Kay Bender for so long. And one of the things I want to add is basically all Kay Bender Rimbaum does is community association law. I see a lot of law firms around the country that they do bankruptcy, they do criminal law. But Kay Bender concentrates in one area, and that's really why they're one of the largest in the state of Florida. Tell people again how they can reach you.
Yes. So the main number for the office, again, is 954-928-0680.
And Kirsten will be back again with us next month. She's always with us the last Tuesday of the month at 5 p.m. Eastern Time. Great job, Kirsten. We'll see you next month.
Thanks, Steve. Bye, everyone.
That's attorney Kirsten Hens. Kay Bender Rimbaum. Listen, if you're a community association, whether it's HOA or Condo, you're not happy with the firm that's representing you, give Kay Bender Rimbaum a call. That's going to do it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.